It's just going to say,
Victoria's story was very good.
And you too, if you went in that room for more than 10 minutes.
I've been in that room many times. I've been on
a weird and unique relationship in that room. And Norm flaunts the fact that he can get away with anything in that room.
Norm is blocked by, I would say, 75% of people on Clubhouse, first of all. It's probably one of the only rooms Norm can go to. So, yeah, he's going to show up there. I'm just saying, I'm putting facts out there. So he can't get on a lot of stages because Norm is Norm. And he just can't control himself. So those are consequences. When you can't control yourself and you offend a lot of people, you get blocked.
Yeah, but people who don't control themselves in Steve rooms get put down in the audience.
No.
Except Norm.
So do you see how that's very open? Norm, and there are a lot of other people that come on stage that I don't agree with at all, but they're able to have their 5 minutes, so to speak, or fresh 5, and speak on what they want to speak of. And
if you vote with her, vote Kitover.
Are allowed to do that. If people want to push back on that in that room, that's allowed as well. So I think that
give me the sign of the open eye.
hello?
That fucking faggot ass shit.
Hello? That's your woman, all right? Is that your wife on the PC? I have some respect.
I'm mad and cry. Oh, pan, you, pan.
Robbed and don't matter. And for the way that I'm looking to structure my business as an international company,
Giving yourself the thing you're asking for, which is another place where we're talking about a spirit from God that is not the Holy Spirit.
Sure, that's fine. I'm saying, but you can't say it's Gabriel. I can make it better.
No, I'm just about discussing about Adam. You've allowed the message from Adam to be a spirit from God, which is not the Holy Spirit. Then you've opened the door to say there's another place other than Jesus that has a spirit from God, which is not the Holy Spirit.
Which is a spirit from God that is not.
The eagle strikes with his jagged claw. The beast emerges, the gods withdraw. A storm of silence, broken law. Pan, you, pan. I am born.
Man has the right to live by his own law, to live in the way that he wills to do, to work as he will, to play as he will, to rest as he will, to die when and how he will. Man has the right to eat what he will, to drink what he will, to dwell where he will, to move as he will on the face of the earth. Man has the right to think what he will, to speak what he will, to write what he will, to draw, paint, carve, etch and mold, build as he will, to dress as he will. Man has the right to love as he will, take your fill and will of love as he will, when, where, and with whom he will. Man has the right to kill those who would thwart these rights. The slave shall serve. Love is the law. Love under will. The law of the strong. This is our law and the joy of the world. Do what thou wilt shall be the whole of the law. Thou hast no right but to do thy will. Do that and no other shall say nay. Every man and every woman is a star. There is no God but man. The rights of man, Master Therian, Frater Purderabo, Alistair Crowley, the Master, Alistair Crowley. Man has the right to live by his own law, to live in the way that he wills to do, to work as he will, to play as he will, to rest as he will, to die when and how he will. Man has the right to eat what he will, to drink what he will, to dwell where he will, to move as he will on the face of the earth. Man has the right to think what he will, to speak what he will, to write what he will, to draw, paint, carve, etch and mold, build as he will, to dress as he will. Man has the right to love as he will, take your fill and will of love as you will, when, where, and with whom you will. Man has the right to kill those who would thwart these rights. The slave shall serve. Love is the law. Love under will. The law of the strong. This is our law and the joy of the world. Do what thou wilt shall be the whole of the law. Thou hast no right but to do thy will. Do that and no other shall say nay. Every man and every woman is a star. There is no God but man. The rights of man, Master Therian, Frater Purderabo, Alistair Crowley, the Master, Alistair Crowley. Man has the right to live by his own law, to live in the way that he wills to do, to work as he will, to play as he will, to rest as he will, to die when and how he will. Man has the right to eat what he will, to drink what he will, to dwell where he will, to move as he will on the face of the earth. Man has the right to think what he will, to speak what he will, to write what he will, to draw, paint, carve, etch and mold, build as he will, to dress as he will. Man has the right to love as he will, take your your fill and will of love as you will, when, where, and with whom you will. None has the right to kill those who would thwart these rights. The slave shall serve. Love is the law. Love under will, the law of the strong. This is our law and the joy of the world. Do what thou wilt shall be the whole of the law. Thou hast no right but to do thy will. Do that and no other shall say nay. Every man and every woman is a star. There is no God but man. The rights of man, Master Therian, Freda Budarabo, Alistair Crowley, the Master, Alistair Crowley. Carthage, though a commercial republic, was the aggressor in the very war that ended in her destruction. Hannibal had carried her arms into the heart of Italy, into the gates of Rome before Scipio in turn gave him an overthrow in the territories of Carthage and made a conquest of the Commonwealth. Venice in later times figured more than once in wars of ambition, till becoming an object to the other Italian states. Pope Julius too found means to accomplish that formidable lead, which gave a deadly blow to the power and pride of this haughty republic. The provinces of Holland, till they were overwhelmed in debts and taxes, took a leading and conspicuous part in the wars of Europe. They had furious contest with England for the dominion of the sea, and were among the most persevering and most implacable of the opponents of Louis Quatorze. In the government of Britain, the representatives of the people compose one branch of the national legislature. Commerce has been for ages the predominant pursuit of that country. Few nations, nevertheless, have been more frequently engaged in war. And the wars in which that kingdom has been engaged have, in numerous instances, proceeded from the people. There have been, if I may so express it, almost as many popular as royal wars. The cries of the nation and the importunities of their representatives upon various occasions dragged their monarchs into war or continued them in it, contrary to their inclinations, and sometimes contrary to the real interest of the state. In that memorable struggle for superiority between the rival houses of Austria and Bourbon, which so long kept Europe in a flame, it is well known that the antipathies of the English against the French, seconding the ambition, or rather the avarice, of a favorite leader, and protracted the war beyond the limits marked out by sound policy, and for considerable time in opposition to the views of the court. The wars of these two last-mentioned nations have in a great measure grown out of commercial considerations, the desire of supplanting and the fear of being supplanted, either in particular branches of traffic or in the general advantages of trade trade and navigation. From this summary of what has taken place in other countries, whose situations have borne the nearest resemblance to our own, what a reason can we have to confide in those reveries, which would seduce us into an expectation of peace and cordiality between the members of the present Confederacy in a state of separation? Have we not already seen enough of the fallacy and extravagance of those idle theories which have amused us with promises of an exemption from the imperfections, weaknesses, and evils incident to society in every shape? Is it not time to awake from the deceitful dream of a golden age and to adopt as a practical maxim for the direction of our political conduct that we, as well as the other inhabitants of the globe, are yet remote from the happy empire of perfect wisdom, perfect virtue? Let the point of extreme depression to which our national dignity and credit have sunk, let the inconveniences felt everywhere from a lax and ill administration of government, let the revolt of a part of the state of North Carolina, the late menacing disturbances in Pennsylvania, and the actual insurrections and rebellions in Massachusetts declare.
I need to be free of those telling me what to do in order to attain my real fulfillment. If I suppress my sensual impulses and urges, I may do harm to my natural development. I am a mature person. I can read whatever I wish, or watch whatever kind of TV program or movies I wish. It doesn't affect me at all if I always say no to others in regard to sex or drugs or alcohol. I will never be accepted by others. I will never have any friends. I don't need confession. I haven't any grave sins. And besides, if I stay away more, there will be less danger of routine confessions. My prayers don't seem to be answered. Seem to be answered. So what is the use of praying? My conscience is the only guide I need. As long as I am at peace with my conscience, I need not worry. Even if some of my acts and decisions are not always with the teachings of the church at and so on without end is the cleverness of the evil one in exploiting our weaknesses, our likes and dislikes. I need to be free of those telling me what to do in order to attain my real fulfillment. If I suppress my sensual impulses and urges, I may do harm to my natural development. I am a mature person. I can read whatever I wish, or watch whatever kind of TV program or movies I wish. It doesn't affect me at all if I always say no to seconds, 10, not 11, 10, not 9. Hold, let it go, 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 go. Santa baby, hold my little Santa baby. Santa baby, hold my little Santa baby. Santa baby, hold my little Santa baby. Strike the master chord, draw the flaming sword. Merry Christmas, Merry Christmas, Merry, Merry Christmas. Take the deepest breath of the day and hold for 10 seconds, 10, not 11, 10, 9. Hold, let it go, 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 go. Because when once an efficient national government is established, the best men in the country will not only consent to serve, but also will generally be appointed to manage it. For although town or country, or other contracted influence, may place men in state assemblies, or senates, or courts of justice, or executive departments, yet more general and extensive reputation for talents and other qualifications will be necessary to recommend men to offices under the national government, especially as it will have the widest field for choice, never experienced the want of proper persons, which is not uncommon in some of the states. Hence, it will result that the administration, the political councils, and the judicial decisions of the national government will be more wise, systematical, and judicious than those of individual states, and consequently more satisfactory with respect to other nations, as well as more safe with respect to us. Because under the national government, treaties and articles of treaties, as well as the laws of nations, will always be expounded in one sense and executed in the same manner. Whereas adjudications on the same points and questions in 13 states or in 3 or 4 confederacies will not always accord or be consistent, and that, as well from a variety of independent courts and judges appointed by different and independent governments, as from the different local laws and interests which may affect and influence them. The wisdom of the convention in committing such questions to the jurisdiction judgment of courts appointed by and responsible only to one national government cannot be too much commended, because the prospect of present loss or advantage may often tempt the governing party in 1 or 2 states to swerve from good faith and justice. But those temptations not reaching the other states, and consequently having little or no influence on the national government, temptation will be fruitless, and good faith and justice be preserved. The case of a treaty of peace with Britain adds great weight to this reasoning, because even if the governing party in a state should be disposed to resist such temptations, yet as such temptations may and commonly do result from circumstances peculiar to the state. It may affect a great number of the inhabitants. The governing party may not always be able, if willing, to prevent the injustice meditated or to punish the aggressors. But the national government, not being affected by those local circumstances, will neither be induced to commit the wrong themselves, nor want power, but intimidation, if it could influence them, or punish its commission by others.
The utility of a confederacy, as well to suppress faction and to guard the internal tranquility of states, as to increase their external force and security, is in reality not a new idea. It has been practiced upon in different countries and ages, and has received the sanction of the most approved writers on the subject of politics. The opponents of the plan proposed have, with great assiduity, cited and circulated observations of Montesquieu on the necessity of a contracted territory for a republican government, but they seem not to have been apprised of the sentiments of that great man expressed in another part of his work, nor to have adverted to the consequences of the principle to which they subscribe with such ready acquiescence. When Montesquieu recommends a small extent for republics, the standards he had in view were of dimensions far short of the limits of almost every one of these states. Virginia, Massachusetts, Pennsylvania, New York, North Carolina, nor Georgia can by any means be compared with the models from which he reasoned and to which the terms of his description apply. If we therefore take his ideas on this point as the criterion of truth, we shall be driven to the alternate either of taking refuge at once in the arms of monarchy, or of splitting ourselves into an infinity of little jealous, clashing, tumultuous commonwealths, the wretched nurseries of unceasing discord, and the miserable objects of universal pity or contempt. Some of the writers who have come forward on the other side of the question seem to have been aware of the dilemma, and have even been bold enough to hint at the division of the larger states as a desirable thing. Such an infatuated policy, such a desperate expedient might, by the multiplication of petty offices, answer the views of men who possess not qualifications to extend their influence beyond the narrow circles of personal intrigue. But it could never promote the greatness or happiness of the people of America.
In the wide field of Western territory, therefore, we perceive an ample theater for hostile pretensions, without any umpire or common judge to interpose between the contending parties. To reason from the past to the future, we shall have good ground to apprehend that the sword would sometimes be appealed to as the arbiter of their differences. The circumstances of the dispute between Connecticut and Pennsylvania, respecting the land at Wyoming, admonish us not to be sanguine in expecting an easy accommodation of such differences. The Articles of Confederation oblige the parties to submit the matter to the decision of a federal court. The submission was made, and the court decided in favor of Pennsylvania. But Connecticut gave strong indications of dissatisfaction with that determination, nor did she appear to be entirely resigned to it, till, by negotiation and management, something like an equivalent was found for the loss she supposed herself to have sustained. Nothing here said is intended to convey the slightest censure on the conduct of that state. She no doubt sincerely believed herself to have been injured by the decision. And states, like individuals, acquiesce with great reluctance in determinations to their disadvantage. Those who had an opportunity of seeing the inside of the transactions which attended the progress of the controversy between this state and the District of Vermont can vouch the opposition we experienced, as well from states not interested as from those which were interested in the claim, and can attest the danger to which the peace of the Confederacy might have been exposed had this state attempted to assert its rights by force. Two motives preponderated in that opposition. One, a jealousy entertained of our future power, and the other, the interest of certain individuals of influence in the neighboring states, who had obtained grants of lands under the actual government of that district. Even the states which brought forward claims in contradiction to ours seemed more solicitous to dismember this state than to establish their own pretensions. These were New Hampshire, Massachusetts, and Connecticut, New Jersey, and Rhode Island, upon all occasions discovered a warm zeal for the independence of Vermont, and Maryland, till alarmed by the appearance of a connection between Canada and that state, entered deeply into the same views. These, being small states, saw with an unfriendly eye the perspective of our growing greatness. In a review of these transactions, we may trace some of the causes which would be likely to embroil the states with each other, if it should be their unpropitious destiny to become disunited. The competitions of commerce would be another fruitful source of contention. The states less favorably circumstanced would be desirous of escaping from the disadvantages of local situation and of sharing in the advantages of their more fortunate neighbors. Each state or separate confederacy would pursue a system of commercial policy peculiar to itself. This would occasion distinctions, preferences, and exclusions which would beget discontent. The habits of intercourse on the basis of equal privileges to which we have been accustomed since the earliest settlement of the country would give a keener edge to those causes of discontent than they would naturally have independent of this circumstance. We should be ready to denominate injuries those things which were in reality the justifiable acts of independent, so varying 'tis consulting a distinct interest, the spirit of enterprise which characterizes the commercial part of America has left no occasion of displaying itself unimproved. It is not at all probable that this unbridled spirit would pay much respect to those regulations of trade by which particular states might endeavor to secure exclusive benefits to their own citizens. The infractions of these regulations on one side, the efforts to prevent and repel them on the other, would naturally lead to outrages, and these to reprisals and wars. The utility of a confederacy, as well to suppress faction and to guard the internal tranquility of states, as to increase their external force and security, is in reality not a new idea. It has been practiced upon in different countries and ages, and has received the sanction of the most approved writers.
On the subject of politics, the opponents of the plan proposed have, with great assiduity, cited and circulated the observations of Montesquieu on the necessity of a contracted territory for a Republican government. But they seem not to have been apprised of the sentiments of that great man expressed in another part of his work, nor to have adverted to the consequences of the principle to which they subscribe with such ready acquiescence. But Montesquieu recommends a small extent for republics. The standards he had in view were of dimensions far short of the limits of almost every one of these states. Not Virginia, Massachusetts, Pennsylvania, New York, North Carolina, nor Georgia can by any means be compared with the models from which he reasoned and to which the terms of his description apply. If we therefore take his ideas on this point as the criterion of truth, we shall be driven to the alternative, either on taking refuge at once in the arms of monarchy, or splitting ourselves into an infinity of little jealous, clashing, tumultuous commonwealths, the wretched nurseries of unceasing discord, and the miserable objects of universal pity or contempt. Some of the writers who have come forward on the other side of the question seem to have been aware of the dilemma, and have even been bold enough to hint at the division of the larger states as a desirable thing. Such an infatuated policy, such a desperate expedient might, by the multiplication of petty offices, answer the views of men who possess not qualifications to extend their influence beyond the narrow circles of personal intrigue. But it could never promote the greatness or happiness of the people of America.
Federalist No. 7. The same subject continued, concerning dangers from dissensions between the states. For the Independent Journal, Alexander Hamilton. To the people of the state of New York, it is sometimes asked, with an air of seeming triumph, what inducements could the states have, if disunited, to make war upon each other? It would be a full answer to this question to say, precisely the same inducements which have at different times deluged in blood all the nations in the world. But unfortunately for us, the question admits of a more particular answer. There are causes of differences within our immediate contemplation, of the tendency of which, even under the restraints of a federal constitution, we have had sufficient experience to enable us to form a judgment of what might be expected if those restraints were removed. Territorial disputes have at all times been found one of the most fertile sources of hostility among nations. Perhaps the greatest proportion of wars that have desolated the earth have sprung from this origin. This cause would exist among us in full force. We have a vast tract of unsettled territory within the boundaries of the United States. There still are discordant and undecided claims between several of them, and the dissolution of the Union would lay a foundation for similar claims between them all. It is well known that they have heretofore had serious and animated discussion concerning the rights to the lands which were ungranted at the time of the Revolution, and which usually went under the name of Crown lands. The states within the limits of whose colonial governments they were comprised have claimed them as their property. The others have contended that the rights of the Crown in this article devolved upon the Union. As
especially as to all that part of the Western Territory which, either by actual possession or through the submission of the Indian proprietors, was subjected to the jurisdiction of the King of Great Britain, till it was relinquished in the Treaty of Peace. This, it has been said, was at all events an acquisition to the Confederacy by compact with a foreign power. It has been the prudent policy of Congress to appease this controversy by prevailing upon the states to make cessions to the United States for the benefit of the whole. This has been so far accomplished as, under a continuation of the Union, to a four-sided prospect of an amicable termination of the dispute. A dismemberment of the Confederacy, however, would revive this dispute and would create others on the same subject. At present, a large part of the vacant Western Territory is, by cession at least, if not by any anterior right, the common property of the Union. If that were at an end, the states which made the cession on a principle of federal compromise would be apt when the motive of the grant had ceased to reclaim the lands as a reversion. The other states would no doubt insist on a proportion, by right of representation. Their argument would be that a grant once made could not be revoked, and that the justice of participating in territory acquired or secured by the joint efforts of the Confederacy remained undiminished. If, contrary to probability, it should be admitted by all the states that each had a right to a share of this common stock, there would still be a difficulty to be surmounted as to a proper rule of apportionment. Different principles would be set up by different states for this purpose, and as they would affect the opposite interests of the parties, they might not easily be susceptible of a pacific adjustment. Not a new observation that the people of any country, if like the Americans intelligent and well-informed, and steadily persevere for many years in an erroneous opinion respecting their interest, the consideration naturally tends to create great respect for the high opinion which the people of America have so long and uniformly entertained of the importance of their continuing firmly united under one federal government vested with sufficient powers for all general and national purposes. The more attentively I consider and investigate the reasons which appear to have given birth to this opinion, the more I become convinced that they are cogent and conclusive. Among the many objects to which a wise and free people find it necessary to direct their attention, that of providing for their safety seems to be the first. The safety of the people doubtless has relation to a great variety of circumstances and considerations, and consequently affords great latitude to those who wish to define it precisely and comprehensively. At present, I mean only to consider it as it respects security for the preservation of peace and tranquility, as well as against dangers from foreign arms and influence, as from dangers of the like kind arising from domestic causes. As the former of these comes first in order, it is proper, it should be the first discussed. Let us therefore proceed to examine whether the people are not right in their opinion that a cordial union under an efficient national government affords them the best security that can be devised against hostilities from abroad. The number of wars which have happened or will happen in the world will always be found to be in proportion to the number and weight of the causes, whether real or pretended, which provoke or invite them. If this remark be just, it becomes useful to inquire state of New York. A firm union will be of the utmost moment to the peace and liberty of the states as a barrier against domestic faction and insurrection. It is impossible to read the history of the petty republics of Greece and Italy without feeling sensations of horror and disgust at the distractions with which they were continually agitated, and at the rapid succession of revolutions by which they were kept in a state of perpetual vibration between the extremes of tyranny and anarchy. If they exhibit occasional calms, these only serve as short-lived contrast to the furious storms that are to succeed. If now and then intervals of felicity open to view, we behold them with a mixture of regret arising from the reflection that the pleasing scenes before us are soon to be overwhelmed by the tempestuous waves of sedition and party rage. If momentary rays of glory break forth from the gloom while they dazzle us with a transient and fleeting brilliancy, they at the same time admonish us to lament that the vices of government should pervert the direction and tarnish the luster of those bright talents and exalted endowments for which the favored soils that produced them have been so justly celebrated. From the disorders that disfigure the annals of those republics, the advocates of despotism have drawn arguments, not only against the forms of republican government, but against the very principles of civil liberty. They have decried all free government as inconsistent with the order of society, and have indulged themselves in malicious exultation over its friends and partisans happily for mankind. Stupendous fabrics reared on the basis of liberty, which have flourished for ages, have, in a few glorious instances, refuted their gloomy sophisms, and I trust America will be the broad and solid foundation of other edifices, not less magnificent, which will be equally permanent monuments of their errors. But it is not to be denied that the portraits they have sketched of Republican government were too just copies of the originals from which they were taken. If it had been found impractical to have devised models of a more perfect structure, the enlightened friends to liberty would have been obliged to abandon the cause of that species of government as indefensible. The science of politics, however, like most other sciences, has received great improvement. The efficacy of various principles is now well understood, which were either not known at all or imperfectly known to the ancients. The regular distribution of power into distinct departments, the introduction of legislative balances and checks, the institution of courts composed of judges holding their offices during good behavior, the representation of the people in the legislature by deputies of their own election. These are wholly new discoveries, or have made their principal progress towards perfection in modern times. They are means, and powerful means, by which the excellences of Republican government may be retained and its imperfections lessened or avoided. To this catalog of circumstances that tend to the amelioration of popular systems of civil government, I shall venture, however novel it may appear to some, to add one more on a principle which has been made the foundation of an objection to the new Constitution. I mean, the enlargement of the orbit within which such systems are to revolve, either in respect to the dimensions of a single state or to the consolidation of several smaller states into one great confederacy. The latter is that which immediately concerns the object under consideration. It will, however, be of use to examine the principle in its application to a single state, which shall be attended to in another place. Dreams give information about the secrets of the inner life and reveal to the dreamer hidden factors of his personality.
My friends, it is wise to nourish the soul. Otherwise you will breed dragons and devils in your heart.
Hidden in our problems is a bit of still undeveloped personality, a precious fragment of the psyche. Without this, we face resignation, bitterness, and everything else that is hostile to life.
We should grow like a tree that likewise does not know its law. We tie ourselves up with intentions, not mindful of the fact that intention is the limitation, yes, the exclusion of life.
You do not have an inferior function. It has you.
For underlying all philosophies and all religions are the facts of the human soul, which may ultimately...
Biggest problems cannot be resolved. They must be outgrown.
The fool is the precursor to the savior.
In spite of our proud domination of nature, we are still her victims, for we have not even learned to control our nature.
Good advice is often a doubtful remedy, but generally not dangerous because it has so little effect.
Archetypal images decide the fate of man.
The underlying primary psychic reality is so inconceivably complex that it can be grasped only at the farthest reach of intuition, and then but very dimly. That is why it needs symbols.
Nobody is immune to a nationwide evil unless he is unshakably convinced of the danger of his own character being tainted by the same evil.
Life calls not for perfection, but for completeness.
To the scientific mind, such phenomena as symbolic ideas are most irritating because they cannot be formulated in a way that satisfies our intellect and logic.
What you call knowledge is an attempt to impose something comprehensible on life.
It is precisely the most subjective ideas which, being closest to nature and to the living being, deserve to be called the truest.
Just as we tend to assume that the world is as we see it, we naively suppose that the people are as we imagine them to be.
Only the complete person knows how unbearable man is to himself.
Doesn't believe that the papers themselves demonstrate that for purposes of the motion to disqualify, the state should be represented by somebody else. And the answer is yes, we want to have an evidentiary hearing up until the point where the court reaches that conclusion. Because that would be the only way for us to satisfy whatever showing the court deems necessary. So I'm not going to waive an evidentiary hearing if the court's saying, well, I don't think we have enough evidence here. Obviously, the answer is yes. What I'm really just saying is, I think that based on the papers, the court can say, yeah, this is a significant problem in a serious case that has really, really serious consequences for Mr. Robinson, for the people of the state of Utah, for the victim's family, and we should do this carefully and correctly. And I think the way to do that is to have the Attorney General of Utah designate somebody in their office to represent this limited purpose until the court determines the scope of the conflict. We think the conflict requires disqualification from the case, but ultimately, obviously, that's going to be the judicial determination. All right. Anything that's rolling on this issue?
showing of a conflict that exists here. Like
For what purpose? To disqualify the office, or to have the Attorney General's office step in and handle the disqualification?
to disqualify the office.
I take a crack at it.
If you wouldn't mind, Mr. Gray, just stepping to the lectern, just so the record picks you up. Sometimes these might be difficult.
If I could take a crack at it. Basically, I think what you're saying is kind of like a French hearing where you have to allege sufficient facts. So that based on those facts, if the court takes that as true, then you would need whether or not there would be a legal basis to conflict it out or find a conflict, right? And so if they don't make that showing, then the court could rule straight way. But if they do make that showing, if what's alleged is true, then we go to an evidentiary hearing is out.
Mostly, it's the initial showing of a conflict, and what happens after that will be determined because they're bringing this up for the first time today.
Basically, like on my facial showing initially, is that what you're saying?
Essentially.
Okay. I think that's, I'll let you.
No, I appreciate your clarification. Mr. McBride.
Nothing else.
All right, it's the court's, and I've read the briefing by all parties and listened to the argument today, and I don't believe a sufficient showing has been made for the court just relying upon the briefing itself. And so I can't make that finding based off, well, I would find that threshold showing hasn't been met based off the briefing. And turning to Mr. Novak, based off that finding of the court, what is your position?
Our view is that if the court has concluded that the briefing does not yet rise to the level of proof that the court should at this time make a referral, then the court should begin to take evidence. And there may be a moment where the court says, okay, I've heard enough, now I'm ready to make a referral, and we're gonna stop and pause, wait for the Attorney General to engage, and then we'll have to see where that goes, but maybe we have to finish the evidentiary hearing. But, I think all of us can attempt to prioritize the portions of our examination so that the court can make that finding as early as possible. I'm just trying to avoid doing it twice. Because right now, it's our view. The state is not being represented by the attorneys who should be represented. And so if the state's going to come in later and say, well, we want to be doing an evidentiary hearing because the state wasn't represented by the right parties, I mean, it just, by the right lawyers, it's something that we would want to avoid. We want to do this once out of the courtesy to the court and to couple witnesses.
No, I appreciate that. And can this be accomplished by proffer?
I don't know what the witnesses are going to say because they've only given us very limited information. The state elected to give us information in their briefing, some of which is, like I said a few times now, is not sworn by affidavit or declaration. It's in the nature of argument. I mean, there are portions of Mr. Gray's brief, he signed it, where he makes many, many assertions of fact in the course of arguing legal issues. And none of that is sworn. And I'm sure that, and I think, so I don't think there can be a proffer because I don't know what the proffer is. I know that I have a lot of questions about things that that the court was not told about in the briefing and the affidavits. So the answer respectfully, no, it can't be done by Brock.
And which witnesses are you intending to call today? I understand you're saying you wish to just put on enough and focus on the key issues, but just if I were to grant, I'm just trying to understand the scope.
Okay, Mr. Ray is the first witness. Second witness, may approach.
Yes. Parties to the bench, please.
Okay.
How much would you pay to be able to read his mind, Noxie? It might surprise you, Lewis, that I do consider the fact that he could be involved in this. Just be objective.
I'll be honest, it was I was just stepping away for like 30 minutes getting ready for the Sabbath. Shabbat Shalom. I apologize. Thank you, counsel. In regards to the question, what witnesses do you anticipate calling?
Mr. Gray, I'm going to get his title wrong, but Mr. Christensen is an investigator with the county attorney's office. The prosecutor, who we believe is conflicted off, and their offspring.
All right. Any input from the state at this point? No. I'm assuming the next portion that we need to address is your motion in regards to the hearing itself, the evidentiary hearing, whether it's closed or open. Correct?
I'm looking over my shoulder at
No, you. No, you. All right. There is someone behind you, but I was trying to look at you. That monitor's in the way, but I appreciate the clarification.
when the county attorneys have informed us of this actual issue, we told them that we thought that there was a disqualifying conflict. We had an agreement that we would file our motion promptly, I think is the correct term, so that certain identities were protected. And that was at their request, and we continued to accommodate that, and we have been following that. So we are not pushing for this hearing to be closed, but we totally understand why it's appropriate to do so. And it is, Mr. McBride has verbalized this very well in conversations with the council. The record is going to be very, very muddy if we can't have examinations that use names and identities. It's just going to be super.
I can't believe it. These viral drape pants for senior women is on massive sale right now. Wow. 70% off with buy one, get us chance to grab these senior approved pants at the best price ever. I love them.
Problem with that. So we are not pushing for this hearing to be closed, but we totally understand why it's appropriate to do so. And it is, and Mr. McBride has verbalized this very well in conversations among council. The record is going to be very, very muddy if we can't have examinations that use names and identities. It's just going to be super.
5 things people love about Look Optic Progressive readers.
I can see clearly, like pop, and then on the bottom.
Well, come on, you telling me you don't do YouTube?
Your Honor, thank you for the accommodation and courtesy to allow us to appear remotely. With me is my colleague David Ryman, who we represent the Deseret News, KSL, KUTV, and other news media. We would like to speak briefly to the closure issue, if that's okay. Counsel for the defendant concerning closure. And counsel has explained that they believe it would be impossible to conduct this hearing or even portions of it in open court without causing prejudice to the privacy and safety interests of the family member witness involved. They told us they believe it would not be feasible or practicable to approach this on a witness-by-witness basis or issue-by-issue basis because they believe the names of the prosecutor and the family member would be used throughout the examination of witnesses. So we have no reason to doubt the statements and representations of counsel, and reliance on those would not be objecting to closure of the evidentiary hearing on the disqualification and the referral issues unless the court has a different view and believes that we could parse this on a witness-by-witness or an issue-by-issue basis. That said, Your Honor, we understand that counsel for the state and the defendant have agreed to review a transcript of any evidentiary hearing and make limited and appropriate redactions so that a public version of the transcript could be released. And with that, there are just a couple other brief points I'd like to make. First, we think that this should be the rare exception to conducting these proceedings in open court. There's a strong constitutional presumption of open and public court proceedings, and of course, the enormous public interest in this particular case. That openness and transparency is an institutional value that serves this court, the participants, and the public well. The facts and circumstances of this particular motion, and given the fact that it concerns a family relationship of the prosecutor, makes it a very extraordinary and unique situation that we feel, given the representations made, can justify the closure. Although we do believe in most cases, just the fact that a motion implicates a witness will not be grounds for closure. Second, we just wanted to get on the record that we believe that release of a transcript is not an adequate substitute for the ability of the public and the press to attend and view the proceedings themselves. For this particular evidentiary hearing, that may be the only practical mechanism for the public to obtain some information about the case. But again, we would expect this would be the exception and not become a regular practice. And finally, Your Honor, it's our position that any oral argument on the disqualification motion or the referral motion should be conducted in a public hearing. As this hearing itself has shown, a lot can be done and argued without disclosing the names of family members or the witness at issue and jeopardizing those interests. Counsel can refrain from identifying the prosecutor or family member to protect the asserted privacy interests. And we have experienced counsel. They can be mindful of that issue during oral argument, and it's not unduly burdensome for them to take those steps. And any burden would be greatly outweighed by the public interest in learning more about the motion and having at least an open argument. So we do believe that the argument, and I understand the argument will be made at a later date, not today, that should be done in open court. That's all I have, Your Honor.
Thank you, Mr. Hunt. Anything further from the parties?
Your Honor, as to the oral argument, it is our request that it be closed. The reason why is that we're not perfect. Names slip. It's happened in trials. It's happened in arguments before. Wow. And I'm concerned of the risk that can have if one of the parties, one of the attorneys, were to slip and identify those who ought to be protected. With that said, a fallback position could be not live streaming the event and requiring any redaction should an inadvertent mention of a name be made.
Thank you. Counsel, one of my biggest concerns is I have to make findings of fact that are very specific. I can't redact my findings when I issue an order, and I will have to cite to the relevant facts and quite honestly, the name of the prosecutor is irrelevant fact. I can't simply glaze over that and make an assertion. It's important because it relates to various factors that you may address, and which has been brought up in briefing. And so this court is going to deny the request to close the hearing as it relates to, and I will take this motion witness by witness. I understand that there may be a witness that this is applicable to, and the court will entertain that. But because this court has to make findings and has to cite to the facts, I need to be able to do that. And since I'm going to do that anyway, which I will, I'd rather address it in an open court. And again, I will entertain any motions, witness by witness, that are going to be called and be respectful of that. But going to Mr. McBride's point, you both have that duty. It's in regards to how you present, and if you're talking about a name that needs to be protected, that's on you, on how you speak. I can't. It seems inappropriate to create a safeguard to prevent you from making a mistake on accidentally saying a name. I don't believe that would be a proper reason to close the hearing just for that. And I understand the pressure, counsel. I know it's difficult, but I cannot accept that as reason to close the entire proceedings for the evidentiary hearing portion. But again, as the witnesses are called, I will entertain the motion whether to close the hearing per witness, and we will address it as we go.
You post stuff in the Jumbotron, go check them out, share them, help me beat the suppression.
Yes, sir. And with that, how would we like to proceed? Well, first, is there any clarification needed on this court's ruling as we're proceeding into the evidentiary hearing?
I just want to clarify. Are you going to entertain motions to close at the outset of every witness? Is that what I understand?
If the motion is made, yes.
Okay, thank you. May we have a moment?
Yes.
They were trying to have their cake and eat it. You shut them down.
Why is he huddling? They're huddling with the defense. What is going on here? The prosecutors and the defense are huddling away from the defendant. There's no fucking way.
I think that's a pretty common thing.
That sidebar is usually held up by the judge.
They'll have it on record. It's just the attorneys talking to each other, not the judge, so it's not necessarily abnormal.
I'll double check that later. I know that a sidebar is a deal, but usually I think it's done by the clerk, but I may be wrong.
No, you're probably right. I probably used the wrong term, but like these sorts of conferences do happen from time to time. Maybe they're trying to come to an agreement and then approach the judge together with like a joint conference or something.
Looks like would it be easier just to go into a brief recess? I don't want to make you feel rushed. You have obviously important conversations. So it's the court's intent to enter a brief recess to allow the parties sufficient time to discuss whatever you need to discuss.
No, I think I'm comfortable moving forward, making my offer right now, and asking you to reconsider that motion. And the reason is because courts, the Supreme Court of Utah, appellate courts refer to witnesses by their initials all the time. In our pleadings, we often refer to witnesses by their initials. In Supreme Court of the United States opinions, witnesses are referred to by their initials. And that's because there's a privacy interest. In this case, I don't think a privacy interest could be clear.
The defense and the prosecutor
This case has polarized the nation in many ways. And there have been death threats made against other witnesses. There have been death threats made. My understanding there's been threats against counsel. Our office has received threats. Doxing is a real thing. Finding people online harassing them online. With the technology that we have now, it's not that hard to find out just about every detail about a person through internet searches, paid subscriptions to programs that do background checks. And we are extremely
serious right now.
We will have
oh, sorry for the language.
A person that does not need to be subject to death threats, to harassment, to doxing, to
don't say his name, dude.
Be avoided. We're very concerned that will happen, and happen to this person for no other reason than this person's father is a prosecutor on the case. Your Honor, I think that there's a way around this that we can avoid
he just
those threats to her, those risks to her, and I think it's by referring to substitute names like we have in the public pleading. So, Your Honor, I would just really ask you to please reconsider your opinion. There's a stipulation from the media to shut this portion of the hearing. There's stipulation from the defense. I think the court in its ruling can refer to the prosecutor as the prosecutor. I think it can refer to child as adult child. I think that would be adequate. I think in a sealed record, there can be references to names. That would be my request, Your Honor. I can't ask more adamantly than I am to defense.
We take no issue with anything that counsel has said. That's why we completely deferred to the state attorney's, the county attorney's initial request that all of the briefing, as much as possible, be under seal and then redacted.
Thank you. One of the points that when I was considering this as a potential issue is that both parties filed a public version of your motions, and you used a mechanism to convey that same information. And I understand that that makes it tricky, but it was a choice of the parties to do that, to issue, to publish those public versions. And the court is fine in regards to particular witnesses referring to those terms that were used in the motions. But this court does not agree that the entirety of the evidentiary hearing needs to be closed. It is a very broad approach to a narrow issue. And I understand and I respect the concerns made by Mr. McBride. And I understand that the court is paid to go witness by witness. If you feel that a particular witness, that needs to be closed, the court will entertain that. I understand the issues of safety, and the court feels the urgency and the importance of that has been stated. But this court cannot find that the closure of the entirety of the evidentiary hearing is proper, given the motions that have been filed publicly online. And I have to leave it to counsel in deciding how you present the evidence, how you state the names. I'm willing to abide by the format used in those public motions, but this court denies a request to use the evidentiary hearing. And again, we'll take witness by witness motion if that particular.
Let's hear the juicy details. Show us what you got. Show us what you got. Hello? 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 They're scrambling.
The court's ready to begin the evidentiary hearing. What we would call Jeffrey S. Gray as the first witness.
Oh my gosh, they're calling Jeffrey!
The courts can move forward. If parties need a break, I'm happy to give a break. I know we're switching gears here. In fact, let's go ahead and take a brief break. We need to relocate our court reporter, so this is a natural spot to take a break.
We have one moment of sidebar.
Absolutely.
He already made his ruling, bro. You ain't gonna talk him out of it.
The sidebar before they dismiss, and they're relocating.
They're really trying to hide his as much of this as they can, it seems like. Both the defense and the prosecutors. It's wild. Well, we're going to see witness testimony, guys. Day 1. This is the first, big hearing. It's not even a real, we haven't even gone to the preliminary hearing where he's going to be arraigned yet. This is kind of like a peek under the hood of what we can expect witness testimony to look like in this case really early. Because the preliminary hearing for the arraignment and the presenting of evidence and probable cause isn't until May when they've gone through discovery. So, yeah, we have a minute here. I kind of got to get there at the end, right? I realize, listening to these lawyers drum on back and forth isn't particularly interesting for a lot of people, but it's incredibly important to this trial, right? These decisions are going to impact the outcome of this trial, which is probably the most significant, high-profile assassination political case in, nearly 100 years. So I think that it merits our attention. And so I had committed to hosting this and broadcasting it, and we're going to stick through it. It looks like we're going to be here for the long haul. So, that being said, get your girlfriend, get your drinks, get your refreshments, get your popcorn.
Get you to
grab your Bible. I would do some praying during this. Our country needs a lot of prayers right now. We need true justice to happen in this case, I think.
To felon astral projection.
I think that a lot of political sentiment rests on the outcome of this case, one way or another, and it's crucial. Oh, here we go.
Ribono Shalom, Ribono Shalom, Ribono Shalom.
Please repost the space, bottom right corner. Thank you so much.
Ribono Shalom, Ribono Shalom.
I think he just has one of those faces where he almost looks like he's always grinning a little bit. So I'm like, is he smiling? I guess what people are wondering. It's kind of his face.
Right, court is back in session. Counsel?
I believe the Inspector General has been informed. Yes, Your Honor, we're asked the court to exclude all witnesses during the testimony of other witnesses.
All right, and to the state, any input?
We agree.
And at this time, would it be convenient to just take a brief recess?
Yes, please.
All right, it's 3:20. How about we come back at 3:30 and resume on the record?
Sounds good.
All right, court is in recess.
Sounds good. Did you hear that?
10-minute break. Did they just say they're going to exclude the witnesses from the hearing? Nachi, you there?
I believe it just means they're going to exclude other witnesses from being in there while a separate witness is testifying, I believe. So not more than one witness in the courtroom at a time.
Okay.
I could be wrong about that, but
I'll look it up. Let me get Noxie back in here. Is she in here? She's showing as in here. Oh, here we go.
A little rachamna.
Yeah, I didn't get a chance to watch the space and what's going on in the space, but I know what's going on. You know what I mean? I wanted to reach out, just come in, grab a mic, say hello, keep up the good work, and knowing that you're probably seeing some things when you met me way back when, saying, oh, I get it now. Because I think I even saw a couple of your tweets where they look like, I was like, so that's the good news, okay? It's always good news, because what we want to do is we want to get to the truth. I don't care who's telling the truth, okay? I just want it to come out, and I want it to happen. And we are undeserving.
Taking a complaint to the wrong department. Diligent can't file that complaint. Only the JCD can. The Jewish Complaint Department. Founded by Cobblers.
Coming out the way that it's being.
Cannabis.
I have no idea. I'm not listening to people that I know are liars.
John Kitover.
I am listening to candidates.
The 16th district write-in candidate to defeat Darren the Hood reporter Shalom.
And they don't, because you know
the followers of the record say it's very useful to say Rabbana Shalom.
She's going to have a
1,000 times a day. Rabbana Shalom.
Be a freaking brain.
Scotty.
Okay, so when I
listen to both sides, people who are skeptical, people who believe in the narrative.
Yeah.
Go ahead.
But it's my feeling. This is my general consensus, and which is lines up a lot. I actually heard Tucker say it, and it really summed it up better for me. Wait, I think can you hear? Okay, summed it up better for me than I did for myself. Is that I'd like to believe that they've got it all figured out, but they're not giving me a very compelling case. And the thing with me is that I'm old enough for the JFK thing, okay? So, and I dug into that for years when I was younger. It was like perpetrated on me and the whole 9 yards. I'm just not buying the Oswald narrative. And moreover, is I remember and I see the damage that was caused because we let it slide. And there's really no reason in this day and age. Like back then, we just had the Supreme film.
Welcome to my show. Harry, you've been a big part of my production here. We're listening to people with Jewish derangement syndrome accuse Erica Kirk and Mossad and CIA of killing Charlie. Rabbana Shalom.
And I mean the majority. The majority of people.
Also, I have another room open called Mocking People. But this is the Jewish Complaint Department. You haven't heard the Jewish complaint yet. But anyways, this is live on X. They kicked me out of the room. Diligent citizen.
To believe that
he's like this dumb fucking schmuck fake news reporter.
This whole entire
all you foul with your fucking brain dead hypnotizing people never read a fucking book in his life.
Yeah, I haven't seen compelling evidence to.
I haven't seen compelling evidence to that's otherwise.
Trial, but thus far, what I've
pronunciate,
seen is
Diligent.
People
Pronunciate.
With certainty that he did the media and the legacy media all repeating the same unsupported narrative, unsupported by primary evidence, that is, right? In unison. Yet,
you always know you're listening to a stupid person when I finish the sentence with right.
Dissenting faction within the right and even in some on the left, not buying it, right?
This is what he does every time he goes back.
Right?
It's
gaslighting.
Gaslighting.
You are a traitor.
Traitor.
Yeah.
Slop up the Fed narrative.
Slop up the Fed narrative.
I was a traitor for exposing
traitors.
Long line.
Trader Joe's. I gotta go grocery shopping, ladies and
I don't
gentlemen.
sell out to anybody.
The Shabbos is nearly here.
That's fine.
The Shekhinah is surely
There's a decent
here.
amount of evidence with that too.
Rabbana Shalom, the followers of the record.
I think.
Say that saying Rabbana Shalom is extremely useful.
I just kind of like, I was sick when this happened, and I just kind of like was busy doing some other things, mostly getting healthy, and I'm really glad that I sat there and
if you've got Tefillin, Harry, now's the time to put it on before Shabbos starts. Because once Shabbos starts, you won't have to put it on anymore.
Fashion, but if I could contribute in a meaningful,
Goodness.
And I don't even have to be on the inside doing it. Like, I don't need the light.
The leather on my Tefillin is cracking.
You know what I mean? I'm
it's all over my arm.
But, if I can be helpful to people, and I am helpful to people on the back end, I give them information.
Hold it close to your heart,
strategies and stuff like that. So I just haven't had time to come in, and I wanted things to calm down a bit. You and I don't have the entirely best background relationship, but we don't have a bad one either. So that's the good news.
Who are you, Grandma?
Bad one either.
Get back to the show.
So,
I'm willing to hear anybody that's bringing evidence to see what they talk about, whether I agree with them, whether they like me or not. It doesn't matter. I talk to people who hate me all the time. I'm okay with it.
Yeah. Well,
I don't hate you either.
Yeah, no, I don't hate you either. But I'm just saying, I saw, like I know where
People
I live.
don't hate you.
I know who's connected to you and all this other stuff.
Room,
And, what do you think they've been trying to shut me up for all these years? You know what I mean? There's a reason for that, Diligent. There's a reason.
There's a reason. We're going to file with the JCD, lady. You're already getting your submission.
How much more runway do I have before? Guess what?
What?
You know what I mean? How much more runway? How much more is my family willing to... How much more am I willing to put my family through?
I don't know. Stop using social media, bitch. Go to the gym.
Yeah. It's like, how much more runway do we have to
the Apostle has arrived.
Obfuscation or opacity.
Yeah, this is it.
Right?
This is it. In my opinion, this is unlike you. I talk to whoever and I ask them. I don't tell people my opinions. When I go out,
You don't tell them?
Across the board, I don't care what religion
Right.
is it. Okay?
Right.
I ask them about this, and I tell them.
Ask them about this.
So we can't let this go. We can't let
You
this go.
can't let it go?
It'll be
What
the end
is
of our
it you're
country.
talking
This is
about?
something
And who
people
are
have to have
they?
a cause. They have
Hello?
to have a cause to get ignited.
You're not saying anything
Feel like
specific,
doing something,
lady.
Do something that's worth doing.
Hello?
It's worth doing. Finding out what happened.
What happened?
Or at least finding
We're
out.
listening to the fucking evidentiary trial, bitch. Shut up. Did they kick me? Oh, my phone crashed. That's generally a sign you've been kicked. I got kicked. Ha ha! He found my profile. He kicked me. We did it again, ladies and gentlemen. The internet is undefeated. Oh, what a life. We're doing it, Balzac. We're doing it. We're calling out everybody who needs to get called out because they're stupid. We're going back in. Deep state operation, Yellow Canary JDS recorder. Candidate John fighting on behalf of the 16th District of Illinois against brain rot.
I didn't catch that. Can you restate that? And something's going on with your mic. It's a little hard to hear.
Is it a little better? Sorry, I'm right by the oven.
That's better.
Okay. Yeah, so the Deseret News, they FaceTimed in, or they video called in. The judge was a little hesitant at first. He accepted the video conference, and they spoke about how it's constitutionally important for the case to be open, as is the precedent, but that this case should be the rare exception for some reason, and ultimately that they were in favor of a closed hearing. Found that very strange.
Yeah, that's a weird position for a news organization to take, to restrict access to information or to have a closed hearing. That's antithetical to their business model. Like, what? That's crazy. Go ahead, Lewis. Is the space glitching out? Lewis, you there? Can anybody hear me?
Hello?
Did I just lose you guys?
I can hear you just fine.
Hi, Aaron. What are your thoughts? Okay, cool. I'm glad I didn't lose it. I think I lost Noxie. I'm trying to fix it now. Let me see.
Noxie Toxie.
Aaron, did you already go?
I didn't. I didn't have my hand raised, but I'm kind of excited to see these attorneys enter.
Yeah, Aaron's talking.
I have to log off in 60 seconds for this.
Remember, show us the Shabbos.
Okay, go ahead,
God bless all of you guys. On the one hand, maybe you guys are about to pull off the biggest journalistic long shot in American history, and you guys alone have the secret. On the other hand, perhaps this was just an exercise in learning how to do investigative journalism as citizens. And with that, I say, God bless all of you. Shabbat Shalom.
Ribono Shalom.
God bless you as well. Shabbat Shalom. Have a good night.
Shabbat Shalom.
Okay. And Jesus be with you. Let's go to James Guru. Go ahead. James Gruber.
I'm Yes, sir.
I just had a question about Mitch Snow. Is that okay?
Yeah. I guess. Go ahead.
I was listening to your interview with him, and he said in the interview that he was vetted by Joe Kent. Do you find that weird?
The work is complete. How much time do you need, Doctor? This Bob is armed. One of you anonymous clubhouse users is the trigger man. Any attempt to flee will trigger the bomb. Okay, his room has crashed, I believe. But we got it going on. We Bono Shell Alarm all the time. Some more Yosele Rosenblatt before we reconnect. Maybe they kick me again. We're going to try to go to another room, see if we can get back in. Here we go. Oh, his room is down. Oh, it's back. Here we go, Rabboni Shalom. Oh, looks like I'm blocked from this room too, or the room has crashed. Let's see if we can find it another way. Oh, here we go again. One more time. Let's see if third time's the charm, ladies and gentlemen. Ah, the room has crashed, Rabboni Shalom. Dunsky. Nothing's working. That's the way it is. That's the way the cookie crumbles. A little Ano Avda for you. Rabboni Shalom. Oy, another Shabbos. Just want to quote Erica Kirk and say good Shabbos. Bono Shalom. I think they actually killed, that might be the end of it because they know they're being live streamed. The actual court, is being live streamed by Diligent, and that audio will go global versus like just having it on local TV, So anyways, interesting times. Rabboni Shalom. The Shabbos has started. Isn't it amazing? As soon as the Shabbos starts, the live feed gets cut. Rabboni Shalom. Another Shabbos miracle. Oh, Rabboni Shalom. Rabboni Shalom.
that censorship.
No offense,
Jeremiah, the translators put it in there to fit the Jeremiah. I'm cool with you, Jeremiah, but like, no offense, we need to go here and appreciate the discussion. Saying in that passage is that it's saying that Jesus is not the son of Allah because he's a creation of Allah. Okay, sure. Let me read this. Okay, I'll shut it down. I'll just show you something. Because it's not about if Jesus is God or not.
Oh my God!
That's not the argument.
The legend has returned. The preservation of the human race.
Sounds G.
Shalom.
I believe I don't believe in society, no.
Let's go. Hello? Hey, what brand is?
Pass. Like, donate.
Can I talk to you, buddy? Yeah, it's fucked up. When did you have? To raise money. Isn't that like the Buddha peace sign you got? What does that mean? And I see the American flag behind that.
So, hey, have you been to,
What is that?
To
It's John Kitover.
No, I haven't heard of that. It's like a cool little, like, it's like, think of like a Barnes, like, you know how they like a Barnes and Noble's like the cafe part? It's like that, but you can like.
What does that mean?
Ribono Shalom Hussein.
Man, you know what, man? I'm with you guys. I just want to know. I just want to talk. What is it you got? There's a lot of, now it's so crazy.
I'm looking at it.
People are fucking polarized. It's either extreme left or extreme right now. There's no.
Softest metric site will ever learn. These are the new guarantee and cloud short sets by.
I've been working on a lot of poetry. Yeah. You want to hear it?
Yeah, man, let's hear it.
This is like a few minutes long. Yo, what's up, Bing? Before I go on, I just wanted to say what's up.
Let the games begin.
Hello?
Hello?
Yeah, I wrote this winter. First made were the angels, and you better believe that angels are real. Demons are angels, cast out of heaven and down to the earth. And the evils of this realm are real. They will deceive you to believe that they aren't here. But they are here. And they are after your spirit, your soul, your louche. Many consider them alien. They mingled and meddled and slept with man's women and gave birth to Nephilim. The giants amongst man, and giants are real. Goliath was real. And David killing Goliath with a sling and ordained king by God was real. God is real. The orb of light that levitated and shot off into the sky, then disappeared, was real. I saw it. I was there. It burned my eyes. And bore witness to the supernatural creator of all timelines, all dimensions, all parallel realities, synthesized and crystallized into one thing, into the entire universe. And it was a man, Jesus Christ. God is man who stood up to the Jewish intelligence community, who stood up to the Roman military-industrial complex, who stood up to the authorities and spirits, sacrificing his own life for the kingdom of eternal life, conquering death to walk amongst us yet again. It is all real. We are at war. It's an ideological war, a civility war. The spiritual war is real. The strong will survive. The
preservation of the human race is dependent on its capacity for resistance to the stripping and mining of your identity, resistance to the comforts of technology designed to control you. Now is the time to free your mind. The artificial wombs that are being built in fields are really there to harvest every ounce of your energy, for the human body generates more bioelectricity than a 120-volt battery and over 25,000 BTUs of body heat, combined with an advanced form of fusion. The elites who worship machines possessed by demons have found all of the energy they need for the technological revolution. They will be sold, some for families, some for organs, some for science, some for slaves, some for soldiers, but the most valuable will be kept in the basement, for they will be keeping the lights on. They will be sold as batteries. Their technocracy is enslavement. Their transhumanism is really an illusion. This illusion is a psychological matrix designed to keeping the war effort appearing to be paralyzed, pulling the wool over our eyes, putting in a tremendous amount of effort into poisoning the water, poisoning the air, putting chemicals in our food, vaccinating liquid metal mercury into our bloodstreams at birth. But this paradigm will shift. This war will be won, not by bullets, bombs, or enslavement, but by using the technology of war written by Sun Tzu, using real ideas, real voices, real talents. Really, the war will be won by the side of mankind, by the side of God, without firing a single bullet. In the beginning, there was only hope, a glimmer of light peeking through a cracked pyramid, filled with the chaos of this realm. It's Pandora's box. No, it's Pandora's pyramid. I was there. I opened it and looked inside, and what I saw was me, broadcasting live from the world ran by AGI, opioid epidemics and biological weapons. God speaks to us through many vectors. We are only as sick as our secrets, and time, it takes time. So let's get honest. We the people are tired. We wake up just to work a job that we hate, just to get by, just to make someone else rich, while we're sitting in our cars, stuck in traffic, contemplating suicide, knowing that there are things worse than death, and living like a slave is one of them. There has to be a way out. There has to be another way. Now is the time to stand up. Stand up for yourself. Stand up for your family. Stand up for your freedom. Become a leader in your life. Speak the truth. The truth will set you free. It is time to get off of the tightrope. It's time to be the tip of the spear. The worst thing that you could do is not say anything, because they manufactured silence, mass manipulate compliance, all under the mantra, trust the science. Standing on the brink of World War IV, addicted to drugs and debt, break free into a heaven, a parallel dimension of eternal life. The voice of God, technology, voice to skull, V2K has got me going mental. God, grant me the gift of desperation. I've seen miracles happen. The orb of light that's shown itself to me disappeared in front of my eyes after morphing in on itself. Where did it go? No. When did it go? I opened my mouth, and it's gone into me. My eyes are open now. The elite have it down to a formula to enslave us and starve out the rest. It's an 8-step process as follows. Step 1, defund the police. Step 2, ramp up homelessness and crime. Step 3, price gouge whole neighborhoods. Step 4, elite ran corporate entities come in and buy the property. Step 5, gentrification with apartment buildings. Step 6, allocate 30% of residential properties to Section 8. Step 7, hike up.
Kitover running for the 16th district against Darren LaHood. I have landed my plane, and I am complete. Thank you very little. God bless. Health, wealth, love. Now go get your fucking shine box, Keegan. Go get your motherfucking shine box. And get your tester and go find out what the light in the fucking dashboard is saying is wrong with the car. Keegan, don't you know I got the volume down and nobody can even hear you over here on my YouTube recordings? Now go get your fucking shine box. Go get your fucking shine box, Keegan. He's giving me from Shemayim. Ribono Shalom. The followers of the Rebbe say that it is extremely useful to say Ribono Shalom over and over and over again. Ribono Shalom. That's what I told DMX at McDonald's. He said, fuck you, motherfucker. I said, whoa, I'm sorry. Rabbano Shalom. He said, what did that mean? I said, it means master of the universe. And he said, motherfucker, let's take that selfie and eat these chicken nuggets. What'd you get? And I said, I got the number 6. I always get the 2 cheeseburgers. He said, are you Jewish? I said, Rabbano Shalom, if I was Jewish, could I eat cheeseburgers? He said, I guess not, N-word. And I said, did you just use the hard R with me? He said, that's what's up, N-word. Because he's giving me from Shemayim. Rabbano Shalom. The followers of the Rebbe say that it is extremely useful to say
You articulate what this first clip shows. I think the clip shows that the camera is zooming in the first clip on Mr. Robinson's lips as he is trying to communicate with me sitting next to him.
Thank you.
If I may reapproach with the second video you're on.
Yes.
It's 5 seconds.
It's like, okay.
Your Honor, the second video is a clip from a court TV posting showing Mr. Robinson's lips moving as he's attempting to speak to Ms. Nesta. And Your Honor, one last thing I'd like to add if I could, which is I think the court very correctly and very cautiously admonished the cameraman about your December 23rd order before this hearing began. And he said he understood the order, and I think the order is very clear as to this lip reader provision. And I can elaborate further why it's damaging, but I think it's obvious to the court if the media is allowed to interpret the conversations between counsel and his lawyer, it creates all sorts of problems in terms of Mr. Robinson's right to a fair trial.
Thank you, Mr. Burke.
Thank you.
And just one more question. I apologize. Just for the benefit of the record, and from your position, citing to the standing decorum order, the violation itself, so we can connect it all from your arguments.
Yes, Your Honor, I forget the paragraph, but there is a paragraph in the court's latest December 23rd decorum order.
It's paragraph 48.
48. And it's been a feature of every decorum order. I think we're on the third one. But from the start, the court has prohibited zoom-ins to allow lip readers to interpret what's being said between counsel and the defendant.
And finally, I think you led with this in regards to the sanctions being requested. You cited to the court sanctions, and the second one referring to, I want to make sure I wrote it down right. Sure. Something along the lines of not showing Mr. Robinson at all. I want to make sure I understood that request.
Sure. The request was either to exclude the cameras for purposes of this hearing in its entirety because of the violation, because we can't be assured that the cameraman's going to comply with the court's order. The second request is if the court is not going to exclude the cameras, then it should, at the very least, order the cameraman not to shoot any footage of Mr. Robinson, that the camera should be focused on the court and the witnesses if the court permits that, but it should not be zooming in on Mr. Robinson. His demeanor, his conversations with his lawyers have nothing to do with the newsworthiness of this case. And what it's allowing is very prejudicial information to be leaked to the public through these lip readers and body language interpreters, and it's creating massive prejudicial publicity for us. So that's the request.
Thank you, Mr. Birch.
Thank you.
I'll hear from other parties if they wish to be heard.
Yes, Your Honor. Michael Judd on behalf of the media entities.
I want to take the court back to that specific paragraph of the decorum order because I do want to make sure we're on the same page about this. The second sentence of paragraph 48 of the decorum order that I understand is at issue here. It does say no visual recording is permitted of a person's lips so as to be decipherable by a lip reader during conferences involving counsel, at counsel tables, or bench conferences with the judge. The zoom in language that you have heard referred to previously doesn't fall in that sentence. The zoom in language comes in the next sentence, which says no one may zoom in on anything on counsel's table or the bench to identify any writing. So those are two separate things. The first that we learned about this was during the break. I briefly reviewed the two videos that the court has reviewed. I understand that those were 9 seconds and 5 seconds long. I identified the provision of the decorum order that I believe applied here, spoke to the pool cameraman about that, ensured that the rule about capturing conversations involving counsel at counsel's table or at the bench so that they may be decipherable by lip readers was an important provision in the court's decorum order that it should be followed. I understand that the cameraman understands that rule, that any capture of those conversations was inadvertent. I understand the concerns raised by defense in this case about potential prejudicial effect of something that is intended to capture conversations. I don't believe that that's what occurred in this case. I believe that the court's order should be understood and applied as written and done so strictly. But I don't believe that there's been a violation here. We've been now on the record for 3 hours. I believe that the total length of the two videos that were shown to the court were 14 seconds long. Whether or not either of those conversations rises to the level of capturing the movement of somebody's lips so that it can be decipherable from a lip reader, I'm not in a position to judge. But I can assure the court that the media is aware of that provision of defense's concern about the potential violation of that order and that they will take that seriously. That's already been raised, already been discussed. As far as the remedy sought here, I think that excluding all cameras from the courtroom for this important part of this important proceeding would be broader than any sort of remedy would be necessary here, as would the direction that the cameras not show Mr. Robinson in any way. I understand that potentially any shot on a still camera, on a video camera of a defendant in a criminal case could potentially be twisted or used by some to try to impute some sort of thought or some sort of idea. But I don't believe there's anything in the court's rules. I don't believe there's anything in the ruling so far to date that suggests that the way to address that kind of concern is to say that a defendant, a critical figure in a case like this, and one that the decorum order clearly allows to be photographed and videoed, be kept off camera altogether. The media continues to take this seriously. Before every single hearing, we speak about the decorum order and what it requires. We recognize the importance of doing it and that there can be consequences if that's not kept. The media understands and hears that, and do not believe that any further reprimand or any sort of further exclusion is necessary here.
Thank you. Well, before I turn to you, I want to turn to the stage. I want to give all parties an opportunity, and then that allows you to respond to whatever they say.
We have nothing to add. We'll submit the issue.
All right, Mr. Burns.
The problem with that explanation, that's the same thing they said last time on December 11th. And on December 11th, there was the same violation. Lip reader, I can pull up for the court what the electronic media did with the prior violation. They hired a lip reader. The lip reader purported to derive a confession from the incident, and they posted that. It's still up there. So it's great that they apologize, but once this kind of damage is done, it is irreparable. And we can't continuously have violations where the media gets up and does this mea culpa, and they just continue to do the same thing. And I point out to the court, this is the same pattern that happened in the Kohlberger case that's discussed in the motion we filed today. And eventually the court there had to order that all coverage of Mr. Kohlberger's face was prohibited. and we attached that order to the motion that was just filed with the court. And I understand the media's desire for dramatic coverage. I understand how they want to incriminate Mr. Robinson, but that process is supposed to happen in a trial, not in the media. And it's a serious violation. It's one that the court should not just wink away and say, I accept the apology, especially after the court was so clear this morning. Calling the cameraman up, asking if he had read the December 23rd order, and his response was, I'm good to go. Meaning he had read it, and presumably he read that provision about zooming in on lips. There's no excuse for it. The court should take some action.
Thank you, Mr. Duncan. Anything further from any of the parties before this court makes a ruling on this issue that's before it? No.
I just want to make one note, Your Honor. Those clips that I showed you are just small portions of much longer footage that was available in the live stream. That was just what we needed to compartmentalize to get it to Your Honor, but it was a much more extensive period of time.
All right, I appreciate this being brought promptly to the court's attention. This is an important issue, and the court takes it very seriously. As it relates to today, well, first, I did put on the record very clearly that there would be potential consequences for any violation of the court's December 23rd, 2025 standing decorum order. For the first part, well, and I've also had a chance to view the two clips that was presented. It was shown to all parties. The first appeared to show an attorney, Mr. Robinson, speaking for about 9 seconds is what my memory showed, tells me or reminds me. The second clip was for about 5 seconds. I believe it was from a slightly different angle, but it also captured that. In both instances, I could see Mr. Robinson's lips moving, and I don't remember about the second clip, but I believe in the first clip it also showed counsel's lips were moving, but notwithstanding, that was in place. I also refer to a statement made by the counsel for the news media, and going to, it is paragraph 48, and I will read it in its entirety. No audio recording is permitted of the conference involving counsel at counsel's tables or during bench conferences with the judge. No visual recording is permitted of a person's lips so as to be decipherable by a lip reader during conferences involving counsel at counsel's table or bench conferences with the judge. No one may zoom in on anything on counsel's tables or the bench to identify any writings. Now, in regards to the zooming, I know there was a representation, and it's easy to, as you're reading, to kind of combine it, but I'm not finding that zooming in relates to the lip reader portion, but that's not material. I do find that, and I'm not a lip reader, so I don't know what the standard is for lip reading, but I do note that 9 seconds in that first clip, one could see his lips moving, and it is a significant time for, as it relates to this particular issue. It wasn't a passing shot. It was focused on these two persons, and so I find that the decorum order, as it relates to section paragraph 48, as it relates to no visual recording is permitted of a person's lips so as to be decipherable by a lip reader, I find that has been violated. In regards to the second clip, 5 seconds, where it shows Mr. Robinson and I believe one of counsel, that I was able to view Mr. Robinson's lips moving. It wasn't a passing shot that it just so happened to capture. It was focused on them. I find that is a violation of paragraph 48 as it relates to no visual recording is permitted of a person's lips so as to be decipherable by a lip reader. Turning to the next section, finding that the violations have been shown as the court has reviewed the purported evidence of these two violations. I turn to the sanctions. Previously, I stated that under Code Section 78B-6-310. If the court finds a person guilty of contempt, the court may impose a fine of up to $1,000, order incarceration in the county jail for up to 30 days, or both. I find that applying this would be disproportionate to what the conduct was in those two clips. And the court notes that it is the court's discretion on whether to apply it or not, this sanction. In addition, the other sanctions, the court stated earlier today, in addition, the court may impose the following remedial measures if warranted. Immediate suspension of video transmission of the hearing, with proceedings continue only on an audio-only basis for this proceeding where the violation occurred, and disqualification, if necessary and narrowly tailored, of the news organization that filed the request in order for the electronic media coverage of the court proceedings for the hearing in which the violation occurred from providing pool camera operator services in this matter where the court determines such a measure is required to ensure compliance with the standing decorum order and protect the rights of the parties. The court also stated that before making a decision, it would allow counsel to make argument or statements, in which the court has done, and that the court's actions are not intended to have a chilling effect on the open and transparent courts or on responsible news gathering, and that the court is fully committed to the presumption of open proceedings under the applicable rules. That being stated, and as the court was listening, Mr. Burt has suggested that one of the potential sanctions is that for the camera for the remainder of the hearing, and not to show Mr. Robinson at all as a sanction for the remainder of today's hearing. And so the court considered that as well. This court does not wish to make a disproportionate decision on the actions, and it does note and does not minimize the violation. Therefore, this court will take up the suggestion by Mr. Burt that during the remainder of this hearing, that the camera shall not photograph Mr. Robinson at all. And that will be the sanction of this court. I will allow the pool camera operator to reposition the camera to adhere to that. First, sir, I'm going to ask you to come forward because I want to make sure that's even a possibility. And again, I don't mean to put you on the spot. I'm simply, I don't want to set anyone up for failure. I don't want to make an order, and if it's not possible, then further sanctions could apply. And I recognize that it wasn't your anticipation to be on your own camera. But as it relates to not showing shots of Mr. Robinson for the remainder of this hearing, what are your thoughts?
I can do that. From where I'm positioned now, I can shoot this lectern, I can shoot the bench, and I can avoid the attorney tables altogether if that is what is desired.
All right. Do you need to do any repositioning of the camera to accomplish that? And I'm willing to give you that time to accommodate that. I don't want to set you up for failure, given what's happened. And so, what are your thoughts?
No, I think the position I'm in, I am okay to avoid the attorney tables at this point and just shoot, this forward part of the courtroom.
All right. Thank you.
Thank you, sir.
All right. Turning to the parties, any clarification needed about the order of this court and the sanction that is imposed?
Your Honor, I only have one. It sounds like this issue is specific to video coverage, and that the order not to take any imagery of Mr. Robinson would not apply, for example, to the still photographers. Do I have that correct?
Well, I'll hear from the parties before I offer that clarification. Do you wish to weigh in on that issue?
Just to indicate to the court that one of the problems is not just with the audio, with the video coverage, but most of the coverage is not covering the proceedings so much as close-ups of Mr. Robinson and comments about his demeanor. So if they catch him in a moment speaking civilly to his attorneys and he happens to smile, that then is twisted into evidence that he's some sort of a remorseless killer. So that applies to the to permit still photography, at least for purposes of today. And I think after the court sees the motion, we'd be in a position to talk about the future. But I think for now, that's our request.
Thank you, Mr. Bird.
Thank you.
To the state.
Nothing further, Your Honor.
And any other inputs? All right. This court narrowly tailors its decision as to the violation. And the violation comes from the camera, the pool camera providing live feed. It doesn't come from the photographer. The photographer is the still, I don't know what the exact term is in this moment, it is eluding me, but the person who's operating the camera to take still shots is under the same requirements for this decorum order. I am not going to sanction them because what was before me with the 9-second clip and the 5-second clip doesn't apply to them. So I'm going to limit the sanction as it relates to the poll camera photographer, again recognizing that the standing decorum order applies equally to the still camera photographer. Thank you, counsel. I appreciate you bringing this to the court's attention and the seriousness and professionalism that you presented this to the court. So thank you to all parties. And again, to the camera operator, you need time to test out to ensure that there is no any inadvertent capturing. I'm willing to do that. I just want to make it clear as day that Mr. Robinson is not to be captured in a sweeping shot in any form for the remainder of this hearing. All right. All right, counsel. With that in mind, how would you like to proceed?
Seriously? We'd ask the court to swear in Mr. Gray.
Mr. Gray, if you would approach and stand before the court clerk to be sworn in.
You do solemnly swear that the testimony you're about to give now before the court will be the truth, the whole truth, and nothing but the truth, so help you God. Thank you. You can sit down.
Mr. Gray, if you'd like, have a seat. Usually we have water bottles. If not, there's one right here. All right. And Mr. Gray, I'm sure you've heard this before, but if you could position the microphones close to you, just to ensure that the record picks up your testimony today. Thank you. Mr. Novak.
May I proceed?
Yes.
Thank you. Mr. Gray, how long have you been associated with the Utah County State Attorney's Office?
3 years.
Okay, and was it 3 years ago that you were elected to be the chief prosecutor of that office?
Yes.
All right. And had you ever previously been associated with the Utah County Prosecutor's Office in any other capacity?
I've defended on criminal appeals. I was a criminal appeals attorney for the state of Utah for 23 years. So I represent the state of Utah on those criminal appeals, which would include Utah County.
Okay. And did you ever have any professional relationship with the Utah County Attorney's Office in any other capacity other than the appellate work you did before you were elected?
Not to my recollection, no.
Because we're in an open session and based on some of the guidance from the court, I'm going to ask you questions. Well, let me back up. How many prosecutors are in your office right now?
Well, that are with our courts that are actively engaged in our court system is 30, and then we have screening prosecutors as well, and that would be another 7 or 8.
Okay, so I'm going to try to
Plus, I should stop because I also, my executive team, they don't have courts, so there's another 5 of them as well.
Okay, so let me ask a better question. How many prosecutors in your office represent the state in felony matters?
Well, all of them that I just described. I mean, even the screeners. Yes, the screeners, my executive team, they are assigned to special cases. Usually my executive team, for example, aggravated murder cases, some homicide cases. So they also are prosecuting and represent the state in trials.
Can you explain what you mean by the executive team?
The executive team would include, obviously myself. I have 2 chief deputies, 1 chief deputy, another chief deputy is general counsel, and then I have a division chief over major crimes and a division chief over general crimes.
So is it fair to say that there are at least 24 prosecutors in your office who have substantial experience prosecuting serious offenses?
24? I don't know that I'd go as far as 24. Okay. Certainly all my SVU attorneys have that experience. Most of my violent felony attorneys have that experience too, but not all.
Okay. And do you know how many attorneys in your office have actually participated in homicide litigation?
I don't know the exact number, but I would say maybe 15.
Okay.
But I guess I should clarify, not all of them have the experience in aggravated murder cases, and that's why we specially assign those attorneys.
Understood. And how many do you believe have experience in aggravated homicide cases?
Probably 7 or 8.
And are all 7 or 8 assigned to this case?
No.
Are the 5 other than you who are assigned to this case experienced in aggravated felony cases?
4, well, either 3 or 4.
Of the 5?
Yeah.
Okay. All right, now I'm going to ask you some questions about a specific member of your office. And because the court may or may not ultimately order that attorney's identity remain sealed, you know what I mean by the word sealed, right?
Yes.
I'm going to refer to that person as Prosecutor A. Okay? You all right with that?
Sure.
Okay. So how long have you known Prosecutor A?
About 3 years.
In your work as appellate counsel for the state, did you have any contact with Prosecutor A?
I may have. I don't recall. We generally send something out to, when we get an appeal, we generally send the AG's office, we send something out to the prosecutor, ask them to fill out anything that we should know. More often than not, they never send us anything. And because it's an appeal, I mean, we're bound by the record. So there's not usually an occasion, but sometimes there is. But I couldn't say for sure that I've never talked. I certainly don't remember ever talking to him, though I could have.
Okay. Is Prosecutor A member of your executive team?
Yes.
Okay. And did you select Prosecutor A to be a member of your executive team?
Yes.
And that was at the beginning of your tenure as the Utah County Attorney?
Yes.
All right. And so you had close working contact with Prosecutor A, who's a member of your executive team for the past 3 years?
Yes.
All right. And that, unless you're out of the office traveling or on vacation, that's basically every work day of the month, correct?
Yes.
All right. And
members of Prosecutor A's family? Let's just start with ever.
What's that?
Ever. Have you ever met members of Prosecutor A's family?
I have met his wife.
Okay.
I don't know if I've met his kids. I may have in passing, but I don't really. If I did, it was like at a function, they say, "This is my family," and introduce me. But I don't remember.
Have you socialized with Prosecutor A and his wife?
I think we went out to dinner once after a conference in St. George with some other prosecutors and their wives.
Okay. Have you ever been to Prosecutor A's home?
No.
Has Prosecutor A ever been to your home?
No.
You engage in recreational activities in any way with Prosecutor A?
No.
Whatever you do, running, pickleball?
No. I need to do more running, but unfortunately I don't.
All right, understood. Okay. Now, Prosecutor A has an adult child who was at the September 10th rally at Utah Valley University, correct?
That is what I mean, I don't have personal knowledge of that other than what they have told me. So I never saw that adult child, but I'm assuming, yes, that's true.
Okay, but on September 10th, 2025, at the moment that Mr. Kirk was shot and ultimately died from that shooting at Utah Valley University, you were in Davis County, right?
Yes, I indicated in the motion that it was Ogden, but it was actually Layton. So it was Layton.
Layton?
Yes.
Okay.
And I think that's Davis County.
All right. That's what I thought. And Prosecutor A was with you?
Yes.
Okay. And isn't it true that while you and Prosecutor A were in Davis County, you learned from Prosecutor A that one of his adult children was at the rally and was texting him about their experience?
Yes. I mean, we had just broken for lunch, and he showed me the text, Charlie Kirk got shot.
And that was a text that he showed you was from one of his children, right?
Yes.
And you knew at the time that it was a text from one of his children, right?
Yes.
What did he say to you? So I'm talking about Prosecutor A.
He said, look at my daughter, look at what my child just showed me. And that's about it. And then he said, you know, I should be getting down to UVU.
Okay. And then he left?
Yes.
And he, as far as you understand, he drove down to UVU?
Well, he drove towards UVU, yeah. He drove in the area. Okay. Ultimately, I met him, and then we drove together to UVU.
Okay, so you, according to the pleading that you authored the pleading that was filed?
Yes, I did.
Okay, so that, for the court's benefit, that's the state's opposition to the motion to disqualify. You authored that, right?
Yes.
All right. And in it, you said that 10 to 15 minutes after Prosecutor A left the event that you were at in Davis County, you left.
Yes,
Did you also head in the direction of UVU?
Yes.
Okay, and then you and Prosecutor A met up somewhere?
Yes.
And traveled to UVU together in your vehicle or in Prosecutor A's?
I
guess there's a third alternative, which is you met somebody else and traveled with them.
I don't remember whose vehicle it was.
All right, did you talk to Prosecutor A?
It was my vehicle, I'm pretty sure.
Okay. So. And was that just about logistical convenience, like let's just go in one car, or was there a specific reason?
Yes. No, that was no other reason.
Okay. And on your way to that, what I'll call the meeting point, did you have any conversations by telephone with Prosecutor A?
Well, yeah, because we needed to meet. He left. I thought I would get some lunch first before I went to the command post. I got about halfway through that and said, my mind was not on it. I needed to go to there, and so then we called. I believe I called him, or he called. I'm not sure who called who, but then we met. We hadn't arranged that when he left.
Understood. But did he convey to you any more information about his child's experience in those conversations?
No.
Okay. And did you inquire, like, how's your kid or anything like that?
I did not.
Okay. And so you met up, and then you went to the command post, which was established near the university, correct?
It was at the university.
Okay. Was it inside one of the buildings?
What's that?
It was inside one of the academic buildings.
Yes.
Right. And did you see Prosecutor A's child there when you were there?
No.
Were you introduced to that person?
No.
Okay. Did you have any conversations with Prosecutor A about whether they should stick around and wait?
No. My understanding, based on, my understanding was that everybody had left. We were told that most of the students had left. They had not, or attendees. So.
Okay, so as far as you know, Prosecutor A's adult child had left the university before he left.
As far as I know, my understanding was that, most of the students had fled. At first they went into buildings or whatever, and then they made their way out.
You are aware, I'm sorry, that's not a question. Give me a second, Your Honor, if you would. So, did you spend time with Prosecutor A at the command post on September 10th at UVU?
Yes. We were going different places, but there would be times that we would meet up. But often not, is all I can say.
Okay. And did there come a time, either on the 10th or shortly thereafter, where he provide you with some information about how his adult child was doing, having been at the...
I don't remember him ever saying anything about that. And I never asked. I probably should have. But I don't remember any conversation regarding his child.
Was there anybody else at the rally who you're friends with, or is a relative of yours, or a close coworker that you're aware of?
I know that there were some people in my LDS ward whose children were there.
Okay. And when you say some people, could you be a little more specific? Like how many different families?
Just members of the ward.
Sure, but do you know how many different families that would be?
I think I was told about 2.
Okay. And who told you that?
One of the families.
Okay, so one of the families in your ward informed you that one of their own children had been there, and then another one had been there?
And then somebody else from the ward had been there.
I see. And do you know who those people are by name? I'm not asking you their names. I just want to know if you came to learn who they are.
Yeah, I came to learn who they are. Yeah.
Okay. And are you close with those people?
We're casual friends with one of them. But I don't think I learned that until well after we had filed the information.
Understood. When did you learn that?
Sometime after. I don't know.
So the information was filed obviously in mid-September.
Yeah, just in 6 days, so.
Right. Okay. And do you know, like, if you saw the children of the families in your ward who you understood were there, if you saw them on the street, would you recognize them?
I would recognize at least one of them.
Did you ever have any conversations with them or their parents about their experience?
I tried to stay away from that, other than me that the one was doing just fine and the other one was shook up.
Okay. And the other one was shook up. Is that the term used, or is that just your way to summarize?
That's my way of summarizing it.
What did they tell you?
Having a hard time with it or something.
Sorry, I interrupted you. So somebody took child. Is their child a student at UVU?
Probably. I mean, they're young adults, so I'm assuming that. I really don't know for sure.
Yeah. And I think what you said is that they told you that their child was having a hard time with it.
What? This is not Charlie Kirk murder trial families. So it was like set up. Yeah.
And do you know if either of those young people who were at the rally, well, I'll put it this way, do you know where they were in terms of in what I'm going to refer to as the amphitheater area?
I have no clue. Really interesting.
The one who was
some fucking
hard time with
there's some fucking shit going on in the Mormon in the
share that information with the prosecution team?
I may have. I don't remember. I may have in passing.
Did you ever suggest to any of the law enforcement officers that person be interviewed because they were impacted by what they experienced?
No. We don't interfere with the investigation. We try to assist. But law enforcement, they identify who they want to locate and who they need to interview, and I leave that to them.
Did the person give you this information, so this is another adult in your ward, tell you more specifically about what their child and the other child actually saw and experienced?
No.
Okay, so you don't really know much more about where they were, what they saw. All you really know is one of them was having a hard time.
Yeah.
With the experience that they had.
Yeah.
Okay. I understand you said that you don't interfere with law enforcement, but if you learn, even if it's somebody you know through your community, that somebody has suffered some emotional harm as a result of a criminal act that you are responsible for prosecuting, that's not information you would give to an investigator so that they could determine whether or not, so that they could go interview that person.
I didn't consider that as really relevant to the investigation, so no.
The fact that this young person was having a tough time with what they experienced is what you're saying isn't relevant? I mean, lawyers use the word relevant. We got to...
Well, it's relevant to them. As far as relevant as to our case, I don't believe so, no.
Okay, understood. Now, there was a point in time in October, I think it was October 20th, where Prosecutor A sent Mr. Robinson's counsel an email disclosing that his adult child had been at the rally, providing us with some information.
Yes.
And so my first question is, were you part of a decision to disclose that information?
Yes.
Okay. And were you part of the decision as to how that information would be disclosed or how much information would be disclosed? Like what led to that email?
Well, there was no decision needed as to how much. The decision was to provide the information that we ultimately provided you, and that is not because we believed that there was a conflict of interest, but that was out of an abundance of caution.
I understand it's your position that you don't think that there's a conflict of interest, but I think that's clear. All right. Did the entire prosecution team, as it was constituted on October 20th, discuss this information that was being disclosed, or was it just you and Prosecutor A?
I know that me and Prosecutor A discussed it, and he may have discussed it with others. I don't believe anybody else was there.
When you discussed it?
When we discussed it, one of them may have been, or two, I don't know.
But the information that you obtained, sort of if I may, in the heat of the moment, back on September 10th in Davis County, that Prosecutor A's child had this experience. And the text messages that went back and forth in the family, that information was shared with the prosecution team, correct? Everybody knew eventually.
Eventually.
Sure.
I mean, yeah, eventually.
Okay, so.
I mean, I only knew the fact that she was there. At the time, I only knew that she was there and that she left. That's all I knew.
Okay, but is it fair to say that you didn't set up any, but I'm going to use a term like firewall, to keep the rest of the prosecution team isolated from this information that one of their colleagues' children had this experience at UVU on September 10th?
No.
Is there a written policy in your office, either that existed when you arrived or that you've prepared since then, for how to evaluate whether one of your prosecutors needs to be screened off from a case?
You know, I'm not sure. I mean, we have those conflicts that come. I mean, the biggest thing on screening for us is if there's a potential conflict where information that the defendant has, one of our prosecutors has, because that's why you screen cases, is to make sure that shared confidences aren't also disclosed to, shared confidences with the defendant aren't shared with the prosecutor.
But you could agree with me that there are other types of conflicts that can arise other than what we might call the, privileged communication.
There may be. I mean, I think there can be. I can't think of any right now, but I think the rules are pretty clear with respect to shared confidences. You can't, screening isn't the end all of how you treat conflicts. I mean, generally speaking, we will just conflict out to another office if we feel like we need to. One example, well, I won't go into that, but I mean, we've been threatened before, and there was an investigation. Of course, we conflicted it to a different prosecutor's office, because in that case, we were potential targets of this individual.
Understood. Okay, so you're not sure if there's a written screening protocol, but what you're saying is when we know when we see it.
Well,
sort of what I'm hearing you say.
Sometimes we do. Sometimes I've had attorneys that felt like they couldn't talk after they've been conflicted out to at least know the victim, but notify the victim that there was that we were going to switch the prosecution. But there may be, I just honestly don't know. We keep an eye on those things and rely on our attorneys to notify us when there is a conflict.
But you knew as of September 10th that Prosecutor A's daughter attended the rally, correct? Was in the crowd, correct?
Yes.
Heard a shot fired, correct?
At that moment, I don't know that I knew that.
You know it as of today.
Sure, I know it now.
Their affidavit.
Sure.
Which says that.
Well, I knew it once all of that information was disclosed to me.
Okay. And that they had to, with many hundreds of other people, run for cover and get out of the open space where they were, correct?
Yeah, I don't know that they had to, but that's what they did.
Well, you've seen the video of, you've seen many videos of that day, right?
Yeah,
so weren't there law enforcement officers basically directing everybody to leave the open space so that they could?
I don't know that I remember seeing any of those videos of the students or attendees leaving. I mean, I know that they left. I know that they ran away. What we learned later is that the shooter left immediately after the shot. So,
but at the time of the shooting, you don't know how many shooters there are, if there's any follow-up, if there are explosive devices, like all those things, right?
Sure.
Okay, so let me ask you these questions about, well, instead of giving you a headline, I'll just ask the question. Once you had all the information about Prosecutor A's child's experience, okay? What they saw, what they heard, what happened to them, the fact that they were separated from their personal property, all those things, okay? What I'm hearing you say is you never really discussed that with Prosecutor A and his family.
No, I mean, I did discuss, I don't know if it was day 2 or day 3, law enforcement was there on the day of the shooting, the next day, and I think into Thursday or Friday, I don't remember exactly which day. And at some point, I was told that Prosecutor A's child left the bag there.
Okay. But you never really talked about it with Prosecutor A, about the impact on his child and the family.
I didn't say that. Not on the day of, or, I mean, in the intervening time, he reported a couple of times that he talked to his child and said that she was doing fine. She reported to him that she was not having any issues.
Did you ever ask him, well, what about you? I mean, your kid was at this.
I didn't. Not that I recall.
Did you ever consult with anybody in the Attorney General's office concerning whether Prosecutor A's child's experience raised a potential conflict of interest for your office?
No, that's what I did for 23 years with prosecutors, is consult on that. And so I didn't feel the need to go to those folks. I mean, I know how to try to figure that out.
So when one of your responsibilities in the Attorney General's office was to consult about ethical issues?
Different matters. It could be a variety of things.
Okay.
And I mean, if you're talking about ethical issues in particular, I don't know that the Criminal Appeals Division was the right folks to consult, but I'm not even sure of who from the Attorney General's office would. So.
Okay, but you worked in the Attorney General's office for a couple decades, right?
Yeah.
And what you're saying is that in your role as an appellate lawyer for the state, you would talk to prosecutors, I guess it's somewhat more informally, about ethical issues.
Yeah, every once in a while, yeah.
Sure. And so my question is whether you reached out to anybody in the Attorney General's office about this particular issue.
No.
Okay. Did you, and when I say you, I really mean you or anybody in your office on your behalf. Okay? Because you're the chief prosecutor, right?
Yeah.
So when I say you, I mean you and people who work for you. What about the Utah State Bar?
No.
I mean, they give ethics guidance to attorneys on all kinds of issues, right?
Yes.
Okay. But no reach out. Other county attorneys in Utah, in other words, your colleagues who are elected chief prosecutors shooters in their counties. Did you discuss this with any of them?
No.
Are you a member of organizations of what I'll call chief prosecutors?
I'm a member of the Utah County and District Attorneys Association.
Okay.
UCDAA. I'm actually the president of that organization. I'm a member of SWAP, which is the statewide association of public attorneys and prosecutors. I'm actually the president-elect of that organization. That's a lobbying organization.
Okay, and do these associations have any mechanism for providing ethical guidance to their members?
No. I mean, when we have questions, we may shoot out an email and ask about things.
Did you do that in this situation?
I consulted no one other than my team.
Okay. I'm going to ask you 3 more categories just to be clear.
Okay.
Did you reach out to any law professors who work to be ethics experts?
No.
Did you speak with any judicial officers about it? Before we get the question and the answer. There you go.
Well, I just said that I have talked to no one other than my team, so.
Okay. Discuss with Prosecutor A whether his child should or should not be interviewed by law enforcement?
No.
Are you aware of any?
Maybe, I don't remember.
Okay, so that may be important. You want to take a minute to think about that?
What's that?
That may be important. Would you like to take a moment to think about it?
I don't remember. I don't think so, but I do not remember.
The brief that you filed on behalf of the state, the opposition to the motion has a couple affidavits attached to it, right?
Yes.
Okay. And one of those is the affidavit of Cole Christensen.
Yes.
And which for the court's benefit in the record is addendum C to the opposition. Special Agent Christensen writes in his affidavit that you and he in mid-December, so that's after the motion to disqualify was filed,
yes,
went to UVU and basically conducted some observations and measurements, right?
Yeah, he was investigating that part. I did go with him because it doesn't involve trial. It's never going to come out in trial. So I did go there and assisted him. But he also had another officer there so that anything that I did could be corroborated by that officer.
Okay, but isn't it fair to say that basically what happened there is you said generally Mr. Robinson's defense counsel had filed this motion to disqualify. I want to have some measurements done because I want to figure out what risks there were to Prosecutor A's child based on where they were and where you believe the shooter was, right?
Yeah, we have very good evidence of where the shooter was.
Okay, so
and it was based on Prosecutor A's child indicated where the location that they were. I'll as you say, and based on the evidence of where the shooter was, so we wanted to confirm that. Now they didn't know where. Obviously where the shooter was, but we wanted to confirm based on, we knew where the shooter was, and so we wanted to confirm that that they weren't in the line of fire. And that was important because that's critical to the state's case, is whether or not someone's in the line of fire.
Okay, so there's a few things there I want to try to make sure I cover. And if Your Honor, if there's any point in time where the court or its staff need a break, just tell me, because I can break whenever the court needs that.
We'll be taking a break shortly, but I appreciate that. And if any of the parties do need a break, please indicate it as well. I want to be respectful to all parties.
Thank you. So the first thing I wanted to address, Mr. Gray, is that you knew that the defense had filed this motion to disqualify based on the relationship between Prosecutor A and somebody who was at the rally, and had the experiences that the court has already heard about. And so you basically went out with a law enforcement officer and you did an investigation and took a number of measurements.
He did, yes.
Okay, but at your direction, right? Because you're the one.
I asked him to do that, yes.
Okay. You say in connection with that there are some uncontested issues in this case. Yes, that's the term you used in your brief, right?
I'm sure that you will tell me where they're not contested, but
well, every issue is contested, right? I mean, okay, go ahead. I'm not trying to have a argument because the court reporter doesn't like
I stopped, so I'm not.
And I'm bad at that too, and I have been for a very long time. But your measurements, as documented in Mr. Christensen's affidavit, Special Agent Christensen's affidavit, are of things that you say are uncontested, but I just want to make sure.
So can I clarify that? I never said that the measurements were not contested. I said what was not contested is the fact of the things that Child A could testify to. That's what I was referring to as what's not contested. Child A, as demonstrated in the affidavit, can testify that Child A was there, that Child A's location, and what the crowd did, what she did, and then what she ran in. That's what's uncontested.
But aren't these also uncontested things which you contested issues which you seem to suggest to the court are uncontested, and that is that the shooter was on the roof?
No, I didn't say that was uncontested. I said what she could testify to is uncontested. And if there was something different than that, that's certainly what I meant. I understand that all those other things could be contested.
Okay. You've made yourself a witness to evidence that you've used to try to advocate to the court that there's no conflict of interest, right? I mean, you basically, even though you're representing the state, you went out and you participated in a what you hope is a systematic way to measure whether Prosecutor A's daughter was in a line of sight from the place where the state alleges the shooter was, right?
Sure.
Okay.
But as far was making myself a witness, I was careful to make sure that there was Cole Christensen and then an officer from UVU. If you look at the case law says that prosecutors can participate in these interviews and so forth. What we do is make sure that someone else is there so that we don't have to testify. And the defense can't force the prosecutor to testify under those circumstances. That's the case law.
It won't surprise you that competent defense counsel have the same practice. We don't interview witnesses without investigators present.
Right. And this was no different than that.
Understood. Okay, I do want to address another aspect of this line of fire situation. Okay, so it's the state's theory of the case, if I may, that the shooter was on a rooftop, correct?
Yes.
Okay. And what's the name of the building that the state believes the shooter was on?
I don't recall.
Okay. And so these measurements that are in Special Agent Christensen's declaration, you're saying were designed to basically, if I may, I'm not trying to put words in your mouth, rule out whether the child of Prosecutor A is in some ways a victim of this incident.
Not as far as a victim. We already understood that based on where the buildings were, that the child was not in that line of fire, but we wanted to provide the measurements for this motion.
So what is the significance of the measurement? What is the significance of whether the child of Prosecutor A was or was not in a physical position where they could have been shot? What is the significance of that?
The aggravator, as you know, is that we're alleging that when the shooter killed Charlie Kirk, that he placed others in grave risk of death. And so anybody within that zone, if you will, was placed in grave risk of death.
Okay, and so you've now gone out and you've done these measurements from the place where you believe the shooter was, and anybody who's positioning at the rally, there's no line of sight. You're basically excluding all of those people from being among those referenced by that aggravator.
That's our understanding. We have a very difficult time proving that others beyond that point were also in that line of danger. I mean, we could, I guess we could make the argument, but that would be difficult to prove.
And so is it your position that because this adult child would not fall within the category of people to whom the aggravator applies, there's no other connection between those people and the prosecution?
Not the crime. I mean, again, depending on whether, again, I rely on law enforcement to provide us with whether they have something helpful or not. We were able to determine based on what child, the prosecutor's child, there was nothing useful. There was no need to provide anything. I mean, we make those determinations when they provide it to us all the time.
Did you work with Special Agent Christensen on his declaration?
On what? No.
On his declaration?
I didn't.
Did somebody else?
Yes.
Another one of the members of your prosecution team?
That's generally the practice.
Okay. Was it Prosecutor A?
No.
Okay, now we've also, I should say, you also filed with the court addendum B to your opposition, which is the affidavit of the child of Prosecutor A, right? And this person is a young adult who is a student at the university, right, at UVU?
Yes.
Okay.
That's what I'm told.
Okay. Did you speak with this adult child in connection with the preparation of their affidavit?
I did not.
Do you know who did?
I do.
Who was that?
It was Mr. McBride.
Okay. And do you know whether Mr. McBride consulted at all with Prosecutor A about that?
I couldn't answer that. I don't know.
Okay. Did you read the affidavit?
Of course. I wrote the opposition. I better read the affidavit.
Did you play any role in the shaping of the affidavit in any way?
No.
It was just given to you, here's the affidavit.
Well, I mean, we were aware of what the student, I'm going to call a student now, we were aware with what the student had said as far as what the student was aware of. And so we obviously, as I started writing based on what my understanding of that was, and I'm sure that Mr. McBride covered those areas to make sure that we were accurate.
Are you saying that the affidavit followed from your briefing and your briefing was based on your...
No, that's not it. My briefing was based on what the information that the student provided. And so to that extent, I'm sure when Mr. McBride talked to the student that he would cover those things.
Okay, so what I'm missing is, where did you get the information about what the student experienced if you have not seen the affidavit?
That was from the prosecutor that is the parent of that.
Okay, so Prosecutor A told you this is what happened with my kid.
Right, I mean, I think that's pretty established.
All right, Mr. Novak, this might be a good time to take a brief break.
Whatever works for you.
And just, not meaning to pressure you, I'm just trying to anticipate how much more time for questions you have for Mr. Gray, just for housekeeping purposes.
It's 4:06 according to this monitor. Oh, that's not right, it's 5 o'clock. The monitor says it's 4:06. That must be some time zone that somebody else lives in. At least another 20 minutes.
All right. So we'll take a 10 to 15 minute break, and perhaps counsel can confer in regards to housekeeping how we wish to address the remainder of the witnesses, whether in a setting today or a different setting. I'm not saying which way, but if you wouldn't mind consulting, and we can discuss that briefly when the recess is over.
That's fine. Do you want to give us some guidance on what works for the court and its staff? Because, I didn't know it was 5 o'clock, but it is.
Right. Go ahead and discuss that, and I'll talk with staff as well. That if it gives me time to speak with them, and then we can confer on with that. All right. Court will be in a brief recess for 10 to 15 minutes.
All right.